It's a huge pleasure to formally introduce Jeremy Waldron to you. Jeremy is universally acknowledged as the leading thinker in the English-speaking world working at the intersection of law, political, and social theory. Institutionally, he's university professor at New York University with an institutional home in the law faculty there. Until 2014, he was also simultaneously Chichely Professor of Political and Social Theory at the University of Oxford. Before that, he taught at Columbia, at Princeton, at Berkeley, and at the University of Edinburgh. He was trained at the University of Otago in New Zealand, as well as at Oxford University. And his books and articles, very, very numerous in both cases, span a wide range of crucial problems that are of both immediate and historical relevance in political philosophy and in law. On the historical side, he's written extensively on Locke and on Kant and on Rousseau. And in the contemporary world, he's written on many of the most pressing issues that have faced political thinkers, including, as Homi just mentioned, cosmopolitanism and neighborliness, and in the last 6 or 7 years, very extensively on the question of democracy and its relationship to torture, its relationship to hate speech, and its relationship to practices of judicial intervention and judicial review. All of this would make Jeremy the natural speaker for our topic, but it's not actually the reason that we thought to invite him. That reason has to do with Jeremy's unique ability to incorporate human and humanistic perspectives drawn from literature, drawn from art, drawn from social theory into the topics of his writing and bring them to bear on the material that he discusses. There's nobody in the world of law and political theory, in which I myself professionally live, who doesn't know for certain that when Jeremy gets up to explain things, he's going to enlighten them by bringing in perspectives from outside those things about which they naturally believe. This comes as a treat in those circles, and at a conference like this one, where our stated objective is to bring to bear different perspectives from the standpoint of law and from the standpoint of political theory onto a problem that rarely makes its way into the humanities itself, namely the problem of asymmetry and warfare, there was literally no other person whom we imagined inviting to be our keynote speaker. And we were incredibly fortunate that Jeremy agreed, because had he not agreed, I'm not entirely sure we would have had the conference. I think we probably would have simply tried to pick a different topic. So I want to say that Jeremy's distinct perspective is about to be on display for you. I don't want to take more of his time, but I want to thank him very, very much for agreeing to come, because it's literally the case that without him, this conference would not have been possible. Jeremy, thank you.
I think almost everything that Noah said was false. But I'm very honored to be on a stage with him, very honored to meet Homi Bhabha for the first time, first of many times, I hope, and thank you so much for inviting me. I almost didn't get here. A combination of a presidential flight out of Boston, Delta Airlines being a little bit delayed on the flight here, and then the roadworks coming into Cambridge meant I got here with 15 minutes to spare. The topic, the title of this evening's lecture is Asymmetric Warfare, of course, Asymmetric Warfare, Insurgency, and Law. I want to consider a number of issues about the role of law in asymmetric warfare. This may be a different perspective from what's been in the earlier panel. Asymmetric warfare, as you will surely know by now, is a term that, as some people have said, it's a term that obscures sometimes more than it clarifies. I'm going to use the phrase to refer in the first instance to disparities of various kinds between the various parties to a conflict, though it can also be used to refer to strategies that seek to avoid an opponent's strengths strategies that seek to avoid an opponent's strengths. Although, as I was reminded at another conference last weekend at West Point, somebody said to me, every military strategy tries to avoid the opponent's strengths. But my comments will be mainly, though not wholly, confined to that form of asymmetric warfare that involves an insurgency against a more or less well-established government. Or perhaps, as in Afghanistan, an insurgency against a power like the United States that is more or less, or has been more or less, an occupation of the country, supporting a regime that the US has tried to establish there. In recent years, we have come to associate the term asymmetric warfare almost exclusively with the global war on terrorism, involving particularly the United States and its allies against organizations like Al-Qaeda and its affiliates. The war on terror is certainly an asymmetric conflict, but maybe it's an atypical form of asymmetric warfare. So what I say will apply to the terrorist case, but I'm going to try and get us a wider view by focusing on the broader category of insurgency. The issue of insurgency shifts us, therefore, slightly away from the terrorist discussion, although American understandings of the global war on terrorism often tend to comprise or take in various insurgencies as well. So we say, for example, that insurgencies against the governments that we support in Iraq and Afghanistan count as part of the war on terror, as well as the insurgencies against the presence of our forces in those countries during a period of something like military occupation. A colleague of mine spends some of his time in New York, Ayao Benvenisti, calls these latter conflicts asymmetric, transnational, armed conflicts conducted by one foreign government in another's territory against non-state actors. So it's a complicated category. But one important difference, and military strategists will tell you this, is that the strategies that are appropriate to use when battling against an Al-Qaeda-style terrorist organization is quite different in character from the strategies appropriate for counterinsurgency. For counterinsurgency, you're trying to support a government's presence in a country. You're trying to win more and more of the hearts and minds of the people who live in that country. There isn't particularly a hearts and minds aspect to the war on terrorism. So I want us to bear that in mind. I think this is going to be important because one of the things I want to talk about is the role of the rule of law in asymmetric warfare. And trying to establish or to put on display one's commitment to the rule of law is a classic counterinsurgent strategy. One tries to present oneself or the regime that one is defending as a rule of law state rather than as an oppressive tyranny. And this has an impact on the use of law as a means by which insurgents might conduct their campaign. Despite these differences, states that face insurgencies do commonly refer to the insurgents as terrorists. The classic case, of course, is the British, who did this from the 1940s through the 1970s in virtually every decolonization struggle that they faced in their collapsing worldwide empire, whether it was in Crete or Kenya or India or Palestine or Malaya or in any of these struggles. They always condemned the people they were struggling against as terrorists, even though formally they were insurgents. Many Israeli commentators refer to Palestinian militants in this way, calling them terrorists. And even now, Americans tend to call insurgents terrorists whenever they are rising against a regime that we support. Is this justified by the tactics that insurgents use? Well, I'm not sure. Our friend Elaine Scarry has suggested that asymmetrical warfare, if I read her rightly, necessarily involves resorting to unconventional weapons and to procedures forbidden by international laws. This was in a paper on rules of engagement in the Boston Review. I'm not sure that it's helpful to regard this as true by definition. Sometimes resorting to unconventional weapons or illegal strategies is what insurgents do. Often they do not. Nor is it the case that the weaker party in asymmetric warfare is necessarily engaged in blurring the soldier-civilian distinction. Those are Moshe Halbertal's, where's Moshe? He's disappeared. Oh, those are Moshe Halbertal's words. Aiming indiscriminately and deliberately at quintessentially civilian targets. That's something that insurgents or asymmetric warriors sometimes do, something that they often refrain from. An Iraqi partisan planting an improvised explosive device to blow up American troops who rightly or wrongly are occupying his country is certainly engaged in asymmetric warfare. I don't know that I would say he was engaged in terrorism. It's just insurgent struggle against identifiable armed forces. Nor can Palestinian attacks on Israeli soldiers operating in the occupied territories be called acts of terrorism, certainly not by definition. Sometimes Palestinian insurgents attack quintessentially civilian targets, other times they don't, they just attack soldiers. Their attacks on soldiers, though they are acts of asymmetric warfare, and though they may be unlawful, are not acts of terrorism, and I think in our analysis nothing much is gained by classifying them as such. So that's what I want to say about words, like terrorism and insurgent. One way or another, I'm going to be mainly concerned with asymmetric warfare in the context of insurgency, whether the insurgents are properly described as terrorists or not. Now, of course, an insurgency is a classic case of asymmetry in warfare. It's a classic case that depends certainly on an asymmetry of material force, at least at the beginning. At least at the beginning in most insurgencies there is a material asymmetry. The insurgents are less well armed than their government opponents. But what interests me particularly is asymmetry of status, asymmetry of legal status. On the one side, in these situations, there is a more or less established state recognized as a member of the community of nations, with all the rights and powers and responsibilities of a sovereign, with organized armed forces at its disposal, along with the whole apparatus of government. So you've got the massive sovereign entity on the one side. On the other side, there is an organization, or as in Syria, a loose and quarrelsome set of organizations whose members belong as citizens to the state just referred to, but who have taken up arms against the state with a view to forcibly overthrowing the current regime and trying to establish an alternative order of government. The insurgents may set up a provisional government as an aspirational institution or to rule the regions of the country that fall under their control, but for most of the time that an insurgency is taking place, that provisional government has no international recognition. It doesn't have the status of a sovereign, and it may not have much domestic legitimacy either. So there you have an asymmetry of status, sovereign versus non-sovereign. I'm particularly interested in this in the eyes of the law. In the eyes of international law, we are dealing with a conflict between a recognized sovereign and a non-sovereign entity, and there are, of course, questions about how international law, especially international humanitarian law, can be made to apply to the non-state entity. Prodigious efforts have been made, as you know, over the years to try to define conditions under which insurgents can get some legal status in the conflict, for which they must pay the price of abiding by a set of legal norms governing armed conflict. What about that? So that's in the eyes of the international legal system. What about in the eyes of the domestic legal system in the nation that they are struggling against? In the eyes of the legal system of the state where the insurgency is taking place, there are, I think, really important questions of legal status. How does the law of the relevant state regard the insurgents? How should it regard them? Should it regard them as criminals, or as combatants, or as both, or in some other category? Those are questions for the legal system of the state. And how should the insurgents regard the law of the relevant state, since it's a law that purports to apply to them and therefore correlatively to be available for their use? Should they be required to respect it? May they make use of it and claim the benefit of its rules even during the course of the conflict? Or, once they initiate armed struggle, do the insurgents lose the right to also continue their struggle by legal means? If it is still permissible for them to have access to law, for example, when individual insurgents are detained by the government they are fighting against, may they then exploit the law and its procedures to try to gain advantage over the government. Now, I'm going to introduce a term. I don't know whether it was discussed. I rather think it wasn't in the earlier panel. The term is lawfare. Like warfare, but lawfare. Yeah? So these questions I've just asked are questions about lawfare. And lawfare is going to be at the center of my interest this afternoon, although I'm going to try to understand it and the problems it gives rise to by discussing it in the context of the indeterminacy that usually exists on both sides of an insurgency as to the role that is to be played by legal proceedings in the course of the conflict. But basically, lawfare is something that insurgents may do. They transfer part of their struggle to courts, either domestic courts or international courts, to try to embarrass the power that they're struggling against or to try to secure some advantage. So a terrorist detainee might do this, trying to use law to protest against either his incarceration or his treatment while incarcerated. And insurgents may do this as well when they have the opportunity. Here's what I want to insist on. A lot of academic writing on this subject, and you can look up lawfare on Westlaw or on JSTOR. A lot of academic writing on the subject, particularly in this country, tends to be riveted too closely to our concerns in particular struggles against terrorist and against partisan organizations in Iraq, Afghanistan, and Yemen. Too often scholarly analysis has been undertaken solely from the perspective of anti-terrorism or solely from the perspective of counterinsurgency. It's a while since there was any writing in American law reviews, for example, that approached questions about lawfare from an insurgent perspective, or in a way that is interested in both points of view in asymmetric warfare. Much of the writing is pessimistic. Can we ever win a war against a weaker party? And much of it is petulant. How dare the weaker party use the weapons of the weak? Which is partly what is going on here. This petulance is reflected in the way the term lawfare is used and defined. Though the person who originally coined it intended it as a value-neutral term, these days it's often conceived of in a way that makes it more or less illegitimate by definition. Major General Charles Dunlap associates lawfare with cynical manipulation of the rule of law and the humanitarian values that the rule of law represents. A couple of law review authors, Chad Austin and Anthony Kolenka, talk of it as a strategy of misusing judicial processes to achieve unwarranted victories. You catch the edge of petulance in all of this. Yeah? The impression that lawfare is wrong by definition is used, some say, to browbeat lawyers and deter them from acting in behalf of insurgent or suspected terrorist clients. Many of you may know a website called the Lawfare Project, subtitled The Use of Law as a Weapon of War. This website offers the following definition. It says, lawfare is the use of the law as a weapon of war, or more specifically, the abuse of Western laws and judicial systems to achieve strategic military and political ends. It consists of the negative manipulation of international and national human rights laws to accomplish purposes other than those for which they were originally enacted. All right? And the website's director, Brooke Goldstein, insists that this negative valence is quite important. She says, lawfare is not something in which people engage in the pursuit of justice. It must be defined as a negative phenomenon to have any real meaning. Otherwise, we risk diluting the threat and feeding the inability to distinguish between that which is the correct application of the law on the one hand and that which is lawfare on the other. So be advised, we're walking into a bit of a semantic minefield here. I won't even begin to untangle the analytic confusion of Brooke Goldstein's passage. Suffice to say, I don't think anything is gained in the way of clarity by begging questions in this way. I shall regard the use of legal tactics in asymmetric warfare as an open question. I do mean an open question, normatively. Open so that we can explore rather than assume in advance possible grounds on which it may be supported, possible grounds on which it may be condemned. Yeah? I believe we can work both sides of that street. Austin and Kolenka compare lawfare to bad business litigation strategies. Yeah? They do so in order to reinforce their persuasive definition of it as necessarily wrongful. But the point reminds us that even in ordinary legal life, people use the law in all sorts of ways, some of them honorable, some of them self-interested. In a business context, people use lawsuits to gain victories that they might not gain through ordinary competition. In politics, advocacy groups use lawsuits in constitutional law for gains that they cannot secure in the legislature. Noah referred to my views about that. We may have views on some of these choices, but it will not do to condemn lawfare in advance and out of hand just because the members of an insurgent group are using it to secure advantages that they cannot secure in any other way. That's the normal reason people have for going to law, to secure an advantage that they can't secure in any other way. And it's not always clear what is meant by describing lawfare as a tactic where the use of law replaces the use of weapons in pursuit of a military objective. What do they mean? In pursuit of a military objective. Armed conflict is usually undertaken in pursuit of a political agenda, and the more sensible way to characterize lawfare is that sometimes you seek that political agenda by military means, and sometimes you seek it by other legal means. The political purpose of the particular lawfare strategy may be to send messages about resolve or seriousness, or to break the will of a political opponent, or to destroy the will of a democratic nation to fight by, this is Charles Dunlap's language, creating risk-averse behavior by US policymakers and military leaders, diverting resources and attention, splitting up international coalitions. Lawfare may be used for propaganda advantage in the hope and expectation that a major superpower such as the US can be defeated through embarrassment. These are all political objectives, not military, although they are political objectives that the insurgents' military effort is also sometimes devoted to. In one rather hysterical passage, Austin and Kalenka try to suggest that lawfare may be the equivalent of targeted killing. Yeah? They say, the paradigmatic use of lawfare is a decapitation strike, where instead of using stealth aircraft with precision bombs, an enemy uses a personal lawsuit against a US commander to harass and distract him from his mission. They're particularly worried that the International Criminal Court may be used as a sort of drone, taking out American commanders by entangling them in lawsuits that may take years to resolve. I suppose such a comparison might have some validity. I wouldn't put much store by it. My view is, as I said, it really ought to be an open question whether and how insurgents should be able to make use of the courts of the regime they are struggling against. I don't want to dismiss the possibility that some legal strategies are manipulative and wrongly so, and I'll talk about that at the end of the discussion. But not all uses of law in the course of an insurgency is like that. So listen, here are the three questions I want to ask. Should regimes use a criminal law paradigm or a military paradigm in their dealings with an insurgency? Or is this a matter of discretion? And whatever choice they make, what impact should the regime's choice on this matter have upon resort to law as a strategy on behalf of the insurgents? First question. Second question. Once those resisting a regime have turned to the use of force as their method, once they've risen up in armed insurrection, is it necessarily wrong for them to complement their use of force with recourse to law, either in the courts of the regime they are fighting against or in regional or international arenas? So that's a specific question about the insurgents' responsibility. And thirdly, as I said, I am going to confront the question, are there any circumstances in which the use of law by insurgents would be wrong, or any types of use of law that would be wrong? Are there any strategies that might be appropriate for a condemnatory use of lawfare? So we have questions about the attitude the law should take to an insurgency and questions about the attitude that insurgents should take towards the law. Bear in mind, we're talking about asymmetric conflict, but we may also be talking about an asymmetry of understandings, because the regime may decide, for example, to use a criminal law paradigm to deal with the insurgency, but the insurgents may think of themselves as military warriors rather than as criminals. It's a gray area, but then, as David Kennedy has explained, so is almost everything in modern warfare. We write sometimes as though this were a new problem, as though until the end of World War II, all armed conflicts were between the forces of sovereign states confronting one another tidily in well-defined battlefields. Of course, that is nonsense. Insurgency is a twilight zone in international law and has been for centuries. The problem has been with us at least since the Napoleonic Wars, not to mention the American Revolution. There's an excellent discussion in a 1999 book by the Palestinian writer Karma Nabulsi, former colleague of mine at Oxford, called Traditions of War, Occupation, Resistance, and the Law. It may seem true almost as a matter of definition that an insurgency is unlawful. Surely it's bound to be unlawful, at least according to the legal system sponsored by the regime. How could it be otherwise? As Immanuel Kant told us in his Rechtslehre, a constitution cannot contain any article that would make it possible for there to be some authority to resist the supreme commander, the sovereign, in case he should violate the law of the constitution. I used to think Kant's position faced difficulty in view of Article 20 of the German Basic Law, which provides in subsection 3 that, and I quote, "All Germans shall have the right to resist any person seeking to abolish this constitutional order if no other remedy is available." But it's not just Germany. All sorts of constitutions make this provision. El Salvador recognizes the right of the people to insurrection, and indeed the obligation of insurrection under certain circumstances. The citizens of the Czech Republic have the right to put up resistance to any person who would do away with the democratic order of human rights and fundamental freedoms established in their constitution. Portugal recognizes the right of peoples to revolt against all forms of oppression. Kant might find this self-contradictory. We can only say that dozens of constitutions cheerfully refute him. But whether or not insurgency as such is contemplated by the Constitution, the violent actions that an armed uprising involves are surely always unlawful considered in themselves because they involve killing and arson and mayhem, especially in its early stages or in cases where an insurgency is largely ineffective, and certainly where hostilities don't rise to any level approaching civil war. Most regimes will be inclined to deal with insurgents under the auspices of the criminal law. Indeed, they will want to maintain this perspective as long as possible, effectively denying their opponents any of the privileges of combatants under the laws of war. All of this is understandable. But it's worth enumerating the difficulties it gives rise to. I'm going to use an example. You'll remember that in the 1970s and the 1980s, the United Kingdom faced the difficulty as to the basis on which it should deal with provisional IRA insurgents in Northern Ireland. On the one hand, the UK used a large force of regular troops as well as paramilitary police to deal with the insurgents. And they rejected suggestions from leaders in the Irish Republic that the soldiers should always be accompanied by police on their patrols. So the UK government used military force against the insurgency. At the same time, the British government insisted, at least after 1976, that those arrested or detained in this conflict should be treated as common criminals and not dignified with prisoner of war status, military detention, or anything like that. Actually, in the early 1970s, they had introduced a category called special category status, which was kind of something approaching prisoner of war status. But this was denounced as a serious mistake by the Gardner Committee in 1975, and thereafter special category status was withdrawn. Now, this was not the view of the IRA people themselves. They thought of themselves as soldiers, albeit in an irregular army. So after 1975, there was not just an asymmetry as between the two sides, there was also an asymmetry of views or understandings as to the status of the weaker side. Members of the provisional IRA presented themselves as soldiers. The British mostly treated them as criminals, even when they were not engaging in terrorist acts against civilians, and even when military force had been used to fight and detain them. This asymmetry of views, you'll recall, was the background to the dirty protests and hunger strikes that took place in Northern Ireland prisons in the early 1980s. The disparity had a number of unfortunate consequences. And there's an excellent discussion of them in a book by the Anglican political theologian Oliver O'Donovan, his book called The Just War Revisited, very little book, terrific piece of work. Oliver said this. He said, on the one hand, the institutions of criminal law proved quite unequal to the task. The criminal courts in Britain were unable to deal properly with the charges brought before them. The standards of proof required in a criminal prosecution were too high. The labour of preparing prosecutions was too long. The process of detection on an incident-by-incident basis too minute to allow an effective response to an organised campaign of war by the insurgents. Furthermore, the system of criminal justice itself became corrupted by the effort to cope with something it was never designed for. In Ulster, there was the era of the special courts, the diplock courts, designed to remove the trial of terrorist offences from the vagaries of the jury system. So the judge would sit as both judge and jury in those cases, a solution which failed to satisfy the expectations of criminal justice, but also failed to guarantee counter-terrorist efficiency. And in mainland Britain, where there were some attacks, there was deep corruption of the courts by fabricated prosecution evidence. O'Donovan's referring to the rigged convictions of the Guildford 4 and the Birmingham 6 in 1975, gravely weakening public confidence in the police. The use of criminal law against the insurgents also affected their views, the insurgents' views, about legitimate targets. When regular police, this is O'Donovan again, puts the point quite strongly, when regular police and criminal courts pursue, prosecute, and try revolutionaries, all those institutions seem to become, in the revolutionaries' eyes, objects of legitimate attack. So even while the IRA, which it did for certain periods, practiced a policy of discrimination, not attacking civilians unless they were directly implicated with supporting the British administration, even while they practiced a policy of discrimination or distinction, nevertheless, judges were shot dead, sitting by their firesides with their children. Off-duty policemen were gunned down as they left church, and so on. Now, O'Donovan's a conservative man, and he's no pushover, but what he says is these distressing scenes could not simply be blamed upon the heartlessness of the revolutionary fighters. They were a natural consequence of the policy of integrating counter-revolutionary resistance into the fabric of the criminal law, particularly when there's this disparity of expectations. Certainly, if the authorities are using the criminal law paradigm to deal with insurgents, or even if they're using a mixed paradigm, they can hardly complain about lawfare. If insurgents are criminals and they have not only the liability to be treated and incarcerated and perhaps even executed as criminals, but they also have the right to bring appeals and habeas corpus petitions and to complain about their treatment. That's what convicted criminals do and are expected to do. Access to law is one of the rights you don't lose when you are convicted and confined in prison for a criminal offence. On this model, then, insurgent detainees must have available to them the remedies at law that ordinary criminals have against police or military violence, against framing and wrongful conviction, against harassment and other forms of abusive treatment. There's no doubt that the British government was massively embarrassed by legal exposure of the rigging of the convictions of the Guildford 4 and the Birmingham 6. But I don't think there was anything inappropriately exploitative of law about those defendants bringing those appeals or those actions. Are the insurgents perhaps estopped from using these remedies by their own insistence that however they are treated by the government, they are, in fact, and in their own eyes, military detainees or prisoners of war? So I say I'm a prisoner of war, not a common criminal. They say I'm a common criminal, not a prisoner of war. Now, I've said I'm a warrior. Am I stopped from using legal strategies? I'm not sure about that. In a situation of asymmetry of expectations, perhaps detained insurgents have to be permitted to play both sides of the game as they judge convenient. They may choose to boycott the courts, as Mahatma Gandhi urged his followers to do in India. But this is a matter of strategy, not a matter of principle, or if it is a matter of principle, it's ethical in character rather than a moral principle governing the laws of armed conflict. But the government, on the other hand, I think is stopped from complaining about lawfare if it has chosen this option. Indeed, it's compelled by its own rule of law principles, such as they are, to permit in hirsutes brought by their insurgent opponents. Okay, so that's a little bit of history. Now, the Northern Ireland history, even though it's, 30, 40 years ago, may seem quaint and obsolete compared to the antinomies that we have been wrestling with in the first 2 decades of this century. But it's not entirely irrelevant. Both the United States and Israel, for example, have used a mixed paradigm, partly military, partly police, partly military detention, partly criminal law, in dealing with at least some of the insurgents that they face. Not only that, but some bona fide terrorists have been tried and convicted, for example, in ordinary federal courts in the United States, even while others have been detained indefinitely as unlawful combatants at Guantanamo Bay, with the benefit, at best, of just military tribunals. Whatever we say about lawfare has to be consistent with the model or models that are being used by the authorities. Of course, we may not approve of every lawsuit that is brought, but that's true of ordinary prisoners as well. So far, I've presented the insurgents' recourse to law as a tactical matter for them, but it may not be purely tactical. It may be a principled part of what they are doing, or in the early stages of an insurrection, it may be mixed in with everything else they are doing and trying as they seek to advance their cause every which way against the regime they are trying to undermine. One week they may be ambushing a police station. The next week they may be petitioning a constitutional court. Some of them may be bringing actions at law even at the same time as others are shooting government soldiers or blowing them up. We may think of this as wrong and inconsistent if you're using both these sorts of strategies. But I want to caution against the use of an overly simple model of the relationship between armed insurgency on the one hand and forms of non-violent protest, such as lawsuits, on the other. When you do political philosophy, a business that I've been implicated in for many years, and when you use political philosophy to address the various forms of resistance to a regime that is judged oppressive, sometimes we imagine a tidy sequence, stage by stage, of various forms of dissidence, beginning with, oppositional political tactics, progressing through lawsuits, and then civil disobedience, all the way through to acts of forceful resistance. And in our pedantic, analytic imagination, we may insist that progression to a given stage on this list is justified only if the previous stages have been exhausted or abandoned. So we say, number one, first comes political opposition. Number two, there is a seeking of redress for abuses through the courts, maybe also through appeal to international institutions. So one, political opposition. Two, lawsuits. Then come various forms of public and disruptive protests and perhaps civil disobedience. That's the third stage. Then fourthly, there may be large-scale campaigns of passive resistance, non-violent resistance along Gandhian lines. Fifthly, if that doesn't work, one may overcome one's Gandhian scruples and move on to acts of forceful individual resistance. Sixthly, there is low-grade armed or more or less unarmed insurrection like the First Intifada in Israel in the late 80s and early 90s. And then at the seventh and final stage, there's the emergence of a full-scale, well-organized armed insurgency. So political opposition, lawsuits, disruptive protest and civil disobedience, large-scale campaigns of non-violent resistance, forceful acts of individual resistance, low-grade armed insurrection, and then finally the emergence of full-scale insurgency. And we have this tidy list in our minds. And the thesis I want to criticize is the suggestion that a dissident group is not entitled to move from one stage to the next stage, from public protest to civil disobedience, or from passive resistance to armed insurrection, for example, unless all the possibilities afforded by the earlier stage have been exhausted. Yeah? So we say, for example, that a dissident group has a moral responsibility to exhaust its legal remedies before it moves, say, to civil disobedience, and that a group has a moral responsibility to exhaust the possibilities of civil disobedience and disruptive protest before moving to violent resistance. We have a very tidy set of stages in mind. And a lot of what's said in philosophy about these matters just really involves that sort of stage-wise process. So if the idea of an orderly progress through these stages can be supported, then there would be an argument against lawfare. For an insurgent organization to engage in a lawsuit in the midst of an otherwise forceful armed campaign indicates that these priorities are not being properly observed. After all, if there is or was anything to be gained from a lawsuit, then recourse should not have been had to armed struggle in the first place. If, on the other hand, the organization has moved justifiably to armed insurrection, then legal methods must have been exhausted and left behind. Do you see how the position works itself out? Of course, it's not always easy to tell. The question is not just whether the courts are still open to the dissidents. John Locke, who is really our best-known classic theorist of resistance and armed insurrection, is realist enough to see that recourse to the courts may be a fake option. Where an appeal to the law, says Locke, and constituted judges lies open, but the remedy is denied by a manifest perverting of justice and a barefaced wrestling of the laws to protect or indemnify the violence of some men or party of men, then it is hard to imagine anything but a state of war. And he goes on, for wherever violence is used and injury done, even though by hands appointed to administer justice, it is still violence and injury, however coloured with the names, pretenses, or forms of law, the end whereof being to protect and redress the innocent. So even courts may be making war on the insurgents. So Locke gives us a hint that things are seldom as tidy as they appear in first-year political philosophy manuals. And the fact is that the progress from one stage to another is very seldom orderly. At every stage in the processes we're considering, and especially when it's a question of insurrection, tactics are likely to be mixed up, and it's understandable that they will be mixed up. Even in ordinary politics, we mix our strategies for political action in legislatures and lawsuit action in the courts. Think of the campaigns about same-sex marriage throughout the countries. People are working both strategies simultaneously. They don't just have recourse to the legal strategy when the legislative strategy has failed. We allow people to work on both. Or think about civil disobedience. We often engage in civil disobedience as a way of initiating a lawsuit, rather than as a method which presupposes that legal remedies have been exhausted, or at least that's the views of some, of Ronald Dworkin in his early work in Taking Rights Seriously, and of the dissenting justices in the US Supreme Court addressing the issue of banned civil rights marches in Walker against the city of Birmingham in 1967. So you mix up civil disobedience and lawsuits, political action with lawsuits. And I think further down the road you can mix them up as well, partly because it's a mistake to think necessarily in terms of a single actor, some individual, or a single organization stepping daintily from stage to stage. At the point where armed resistance looks like being necessary, often there will be multiple factions, suffering various grievances, emphasizing various priorities, facing various risks, possessing various capabilities, moving at different paces and seizing different opportunities. Think of the early stages of the insurgency in Syria, for example. There's never just one actor moving tidily from stage to stage. There are multiple actors, multiple organizations. That one group has moved on to armed struggle does not disqualify a second group, for certain purposes loosely associated with the first, from resorting to legal action. The factor of risk is particularly important. Violent opposition to a regime is a massively dangerous process for those who engage in it, and groups will embark on these risks with varying degrees of hesitancy, not always burning the boats of other modes of engagement behind them. So what might happen is that an insurgency, which is, say, in its early stages, may be accompanied by various forms of peaceful protest or various forms of protest that teeter on the brink of disruption and violence. Or you may have an insurgency in which some factions continue to pursue legal remedies, even while some of their brothers in arms have actually unambiguously taken up arms. And remember, too, that it takes two to tango on this. What is appropriate and inappropriate for an insurgent group to do will depend in part on the activities and actions of the government and regime that it opposes. A government under pressure from the insurgency on the streets or in the mountains, a government seeking as part of its counterinsurgency strategy to win the hearts and minds of the population, may be persuaded, out of some manual, to emphasize the rule of law and to make its courts available in a new way where they weren't available before. Is the insurgency obligated morally to spurn this opportunity simply because it has already initiated hostilities? Surely not. Sometimes an insurgent group will engage in limited armed struggle with the hope that this may pressure the government to adopt some legal, or to make available some legal forms. Other times it will simply seize legal opportunities as they arise to complement other strategies to which it is already committed. So I don't think we can really invoke this tidy, stage-wise process as a basis for denouncing lawfare. Well, now I want to move on to my third question, which concedes, nevertheless, there may be some uses of the law that are inappropriate for insurgent or terrorist groups. Sometimes there may be illegitimate forms of lawfare. I don't know that I can do justice to all the concerns that people have expressed about this. Some of it, as we have seen, is hysterical. The term lawfare has been used to describe the nefarious exploitation of international law for propaganda purposes by orchestrating civilian deaths or by framing Americans for war crimes. This, we are told, is no idle fare. During the 2003 invasion of Iraq, reports surfaced that US military uniforms had been stolen and insurgents intended to use those uniforms to pose as US military soldiers and to commit war atrocities. I have no idea about the credibility of those reports, but obviously that would be an abuse. If I had to name a particular form of abuse of legal procedure associated with lawfare, it would be something like this. Sometimes protesters or insurgents seek to provoke violations of law on the part of their opponents. They seek to provoke violations on the part of their government opponents, on the part of the soldiers or the police officers facing them, so that they can exploit the resulting violations for legal or propaganda advantage. So they taunt and insult the officers, or they throw bottles or rocks, daring the officers to come out of their lines and beat them or shoot them, all with a view to filming and exploiting the beating and the shooting. Or a detainee may taunt or assault the guards in charge of his captivity, hoping to provoke an incident which can be similarly turned to his advantage. I think in some cases this is wrong and reckless. It's wrong, I think, because it instrumentalizes the fragility of the laws that we hope the officers are supposed to be bound by. It instrumentalizes that fragility. The hope is that the laws will prove unequal to the task of restraining the police or the soldiers, and that this will then redound to the benefit of any protesters or insurgents who have a camera and a lawyer. Yeah? The law is known to be fragile, and sometimes people want to exploit that fragility for their own purposes. I think that's a wrongful form of lawfare if the aim of the whole incident is to provide a basis for a lawsuit against the authorities one is combating, or even if no lawsuit is envisaged, if it's supposed to be a way of securing a propaganda coup. I said it's wrongful because it instrumentalizes the fragility of the laws. What do I mean by that? Well, let me explain. Laws governing protest and insurrection, laws governing armed conflict in bello, laws governing the grey area of response to insurgency, have a difficult task, to say the least. They have to operate in a most unpropitious environment. They must do their work in circumstances of great danger and panic and anger, and often in circumstances where ordinary restraints on behavior are already largely withdrawn. They have to restrain people, soldiers and police officers, from doing many of the things that those officers feel impelled to do as a way of defending themselves or as a way of responding to attacks on them or on their honor or as a matter of anger or righteous fury. They are laws for people, again, soldiers and police officers, who characteristically are already at the limit of their endurance and who do not see very much in the way of reciprocal self-restraint again amongst those who are facing them. So the human motivations to which laws governing protest and insurrection and the laws governing armed conflict have to oppose themselves are already very powerful and unruly. These laws have to sort of clamp down on tremendously powerful motivations. At the same time, the relevant laws are fragile in themselves. They're not necessarily well established. They're not necessarily rooted firmly in the ethos of those to whom they will apply and well-established traditions of self-discipline and self-application. In the nature of things, those charged with obeying these laws, soldiers and officers, sometimes have to act in small groups without supervision and in situations of great anger and great danger. Whether these laws will work or not is very much dependent upon what the ordinary soldiers and police officers do and whatever ethos grows up among them. We know that any legal rule can survive a certain amount of violation and still survive, but the distance from a certain number of violations to the tipping point at which the law collapses and simply becomes unequal to the task may be quite small. The amount of non-compliance that can stand and still survive may be quite limited, maybe not for the ordinary criminal law, but certainly for the laws of war and certainly the laws for dealing with grey areas of insurrection. I believe that in those areas we're quite close to this threshold a lot of the time. The principle of distinction, we know, is already honoured, often in the breach and sometimes defied by whole units, indeed by whole military organisations. And the knock-on effects of perceived violations, especially if these seem like acts of policy, are likely to be extensive. Because of what is at stake for any group in armed conflict, because of the problem of the costs of compliance, because of the temptations of positional advantage and the fear of being taken advantage of, any sense that others are securing an advantage in armed conflict by violating these norms is likely to lead to their opponents violating them as well. At the same time, the work that these fragile laws have to do in these unpropitious circumstances is tremendously important work. These are deadly serious laws that have deadly serious work to do in a deadly environment faced with deadly motivations. It's tempting to say that the more important the law, the greater the case there is for those whom it addresses to comply with it. That's certainly correct. So the soldiers need to understand these laws are very important. They need to respond very carefully to them. But it's not just a matter for those who are charged with compliance, it's also a matter for all of those whose actions will have an impact on compliance, and that may include some of those whom such laws are supposed to be protecting. Am I blaming the victim here? Well, kind of. If someone sets out to provoke violation of these laws, which they hope subsequently to exploit, if someone sets out to provoke violations of these laws by enhancing or intensifying the motives of fear and anger that the law is already having to face down, then I say those people are acting with reckless indifference to the fragility of these laws, treating them not with respect, not as something that they too have an obligation to help uphold, but simply as a resource to be exploited, an occasion for a lawsuit from which they may gain some tactical advantage. I'm saying everybody has an interest in the integrity of these laws, insurgents as well as police officers. Everybody has a responsibility to do what they can to help these laws gradually establish themselves in the fraught environments in which they have to operate, or at least they have a responsibility to act in a way that doesn't make it harder for those laws to survive or easier for them to crack under pressure. That's what I think about this question of whether lawfare is ever inappropriate. It's the closest I can get to an account whereby there may be something wrong with exploiting law in this method. I don't mean that the lawsuits subsequently should be dismissed or the soldiers should be excused from the violations that they have committed. I just mean that the provocative behavior itself is a problem in these circumstances. And it's important to see how narrow this case is and how complicated the argument has been for condemning this particular form of lawfare. Only a very few cases of lawfare will fit into this category or other categories that ought to be similarly condemned. For the most part, I really do believe there can be no ground for complaining as a matter of principle about the use of lawsuits by insurgents or by insurgent or terrorist detainees. Of course, there can be reason for opposing such lawsuits, reasons for defending against the allegations they embody if those allegations are thought to be ill-founded, but that's what defendants always do. That's business as usual under the law. I want to conclude with a few remarks on the rule of law, and the rule of law is a possible source of vulnerability. Opponents of lawfare, opponents of the use of law by insurgents, say that this is a weapon of the weak. I don't mean weapon of the week like weapon of the month. I mean, this is a weapon of the weaker party. Yeah? And so it is. That's the thing about the rule of law. It empowers the weak to resist the strong, empowers the weak to resist those who would otherwise use their inherent strength to exploit, dispossess, or subordinate them. That's what the rule of law is supposed to do, and usually we complain that it doesn't do enough of it. It seems odd for a rule of law state to complain that law is being used against it to prevent it from achieving outcomes with its sheer material power. What is sometimes said is that a more powerful nation can lose in asymmetric warfare because the rule of law requires it to fight with one hand tied behind its back. This is Aaron Barak's phrase from the Israeli Supreme Court in the torture cases. Barak recognized the point of these rule of law constraints, the point of fighting with one hand tied behind one's back. The point of that is not to even the odds. It's not to reduce the asymmetry, to make the struggle into a fair fight. If the purpose were just to even the odds, then we might be tempted to untie our hands if we thought we were beginning to lose more often than we ought to. No, if we tie our hands behind our backs, we do so because we believe substantively in each and every one of the legal constraints that are imposed. We do believe that detainees should not be abused, that due process should be followed, that stone throwers should mostly not be shot, and that civilians should not be slaughtered or brutalized by our efforts to winkle out a few insurgents. To commit ourselves to these principles is to commit our legal system to entertaining and hearing complaints by the weak, again, not by the month, by the weak people, that these principles are being violated. Such complaints are no doubt embarrassing, but they are not for that reason a weapon forbidden to the weak. And it's more for that. It's more than that. Respect for the rule of law is generally accepted, as I said at the beginning, as a key element in counterinsurgency. A government's respect for legal rules can provide a key to gaining widespread and enduring social support. It can be a basis for renewing legitimacy. As such, it is something whose presence and effectiveness may accrue to the benefit of the strong, though it does so precisely because the strong are fighting with one hand behind their back. It's an important paradox. By weakening oneself, by fighting with one hand tied behind one's back, one increases one's legitimacy and therefore can fight more effectively. E.P. Thompson explored this in his famous rule of law coda at the end of Whigs and Hunters, a great 18th century Marxist historian who suggested that on the one hand the law did support class dominance, on the other hand the law mediated those class relations through legal forms which imposed again and again inhibitions on the actions of the rulers. Not only were the rulers inhibited by their own rules of law against the exercise of direct, unmediated force, like the employment of troops against crowds, or torture, or all the other conveniences of power with which we are all conversant, but they believed enough in those rules to allow in certain limited areas the law itself to be a genuine forum within which certain kinds of class conflict were fought out. There were even occasions when the government retired from the courts defeated. Such occasions served paradoxically to enhance the legitimacy of the government. But at the same time, by doing that, they nevertheless also empowered the insurgents. And there's no end to this dialectic. It goes back and forth. The weak sometimes win, and the powerful sometimes gain by acknowledging their own defeat. Austin and Kalenka say that a country built on law is made vulnerable by law, but that a country that proves vulnerable by law is more legitimate as a result, and therefore built more strongly. So my aim in this lecture has been to convince those who are disposed to complain about lawfare to try to think in some of these complicated and perhaps paradoxical ways about the importance of law, the appearance of law, the processes of law, and the rule of law in a state, even when that state is in crisis, even when that state is facing insurgency. And to think about us as a sponsor of such states, to think about these matters as well. Legal processes can be abused, I've conceded that. But perhaps if we want to display the distinctive advantages of the regime that we are defending, it may be a good idea to enhance, or at least not diminish, the provision that is made for law and legal action in the course of asymmetric warfare. That's it. Thank you very much indeed. field the...
I'll moderate and field the questions.
Right.
Jackie.
Thank you for that absolutely marvelous, comprehensive and stimulating lecture. I just wanted to ask you about your third point about situations in which insurgents might exploit the fragility of the law, and to really just push you. I'm not sure what I'm saying is right, but just to push you. Think of situations where the British government used, the 5 uses of torture against the IRA prisoners, or where these Israelis used position torture against Palestinian detainees, or waterboarding, or Guantanamo. So I'm thinking of those situations in which, insurgent groups, or if you like, the weaker party in an unequal situation, as you described it in the beginning, is being clearly abused within a sort of legal framework. In that context, might it be ever legitimate for insurgents to really draw attention to double standards in a way by creating kind of a legal forum of their own sort of choosing, even if that legal forum is in some sense an act of what you might call perfidy or abuse? Yes. So, in other words, is there ever a situation in which that kind of exploitation of fragility might be justified by the manifest inequality and abuse of law by a stronger power?
Thank you. I mean, I think the answer is that more or less always it's appropriate in those circumstances. But let's think of why somebody might say it's not. The Lawfare project online says that there is sometimes circumstances where insurgent groups or terrorist groups say to their members, try to get yourself tortured, and if you are tortured, then try to bring it up. And I don't know how you get yourself tortured, I suppose by refusing to give information, and that's the provocation. I would be very, very hesitant indeed about trying to fit that into the very, very narrow category I was trying to define. I suppose if there is some cynical attempt to elicit torture, as there might be to elicit a beating, for example, then we might have some worries along the lines that I indicated. But I didn't intend to take in these cases at all unless there was a deliberate attempt to manipulate the fragility of the laws against abusive interrogation, for example.
Can I ask just a quick follow on that, Jeremy? What about a case where an insurgency places itself intentionally among civilians in the hopes that not only, in the first instance, they would like not to be attacked,
sure,
but in the second instance, if attacked, they would elicit some sort of a violation of international law. Would that strike you as an example?
That would strike me as an example of what I had in mind. So there I'd want to say, look, this principle of distinction is so important that people shouldn't try to instrumentalize its violation in that way.
Because you said it was a very rare case, and I'm not sure how rare a case that in fact is.
Yeah, maybe that's more common than the sort of the rock throwers who are hoping for bullets in response. Okay, so I'm prepared to back away from very, very rare case. I wanted to say it was at least a narrow case for these reasons. So I think we can expand it in this direction, but I would really want to say that mostly it will be limited in the direction that the questioner raised.
Michael Ignatieff.
I enjoyed the lecture enormously, but I was struck by the fact that your characterization of the legitimacy of insurgent strategies was indifferent as to the character of the regime they were opposing. But in common sense, it makes a difference whether the insurgency is occurring against a rule of law state or a systemically rule-violating state. What difference does that make to your account if you differentiate between regime types?
Yeah.
And secondly, what's the function of last resort here? I liked your point about, let's not do stages here. I get that.
Yeah.
An insurgent will use the weapons of the weak that are available. But in legitimacy terms, it makes some difference as whether violence is a first resort, second resort, third resort, or in just war terms, a last resort. How do you think about those issues?
Yes. The last resort, I don't have much more to say than that I already said, which is the logic of last resorts, first resorts, middle resorts. It's never going to be as tidy as that terminology indicates. There are going to be new opportunities, there are going to be new possibilities, there are going to be multiple organizations facing different risks and with different grievances. So I think it has to be possible for there to be movement back and forth. Having said that, one should be very, very careful before taking up arms, and one should do so only in extremis. But in extremis may not necessarily be exactly the same as last resort, in the sense that no other resort is imaginable or no other resort is possible. It may well be, for example, that the insurgency can't get the courts open to them except with a little bit of fighting. And so that's on that point. I said nothing about the justification of the insurgency. And I'm a fan and follower of Michael Walzer on this. I believe that there's a big distinction between jus ad bellum and jus in bello. I believe we have to develop an account of the rights of insurgents in armed conflict, which is separable from the view about whether we justify them going to war. Of course, the character of the regime came into play in a number of ways, because whether it's a rule of law regime that is being fought against here will affect what the possibilities are for the insurgents. But there's no suggestion, I wouldn't want to make the suggestion, that a rule of law regime should not be the target of an insurgency in the first place. South Africa would be a good example. Apartheid South Africa was largely a rule of law regime. The courts were open. At the same time, it faced an insurgency because of the massive substantive injustice that was associated with the rule of law structures. So I don't want to argue backwards in that way from the rule of law consideration.
Homie.
Just to follow on from that very quickly, do you think that the ways in which the legal apparatus, even in rule of law regimes, is constructed, would be able to take the moral pressure and weight of what I very much agree with you? You can't think of insurgency as a stagist, progressive thing, either morally or structurally,
right,
or politically. Do you think that could be absorbed into a rule of law regime, or would it violate its own forms of temporality, self-narrative, and so on?
It's a very, very good question, which partly means I don't know the answer. But because we might say, take a typical rule of law state. I'm a New Zealander. New Zealand is a paradigm rule of law state. And New Zealand has not faced serious insurgency since the 1860s. And it's not rigged for dealing with insurgency, and it would have to make all sorts of compromises. And bringing insurgency within the system would put it under all sorts of strains. On the other hand, and this takes back some of what I said to Michael, if you run a system with massive substantive injustice, and you know, even though you defend the injustice, that it's regarded as oppressive by other people, then you're going to have to be prepared to deal with emergencies, to deal with insurgencies, and you're going to have to rig your rule of law system with certain numbers of safeguards and buttresses to try to take on board the possibility. But I do think you're absolutely right that dealing with this under the rule of law, even if you're not using the criminal law paradigm against the insurgents, but you're just being receptive to their lawsuits, then you are posing, I think, great strains on the rule of law system. And so something maybe that the less hysterical opponents of lawfare may be thinking is that we shouldn't subject a rule of law system to these sorts of strains.
Thank you very much. Jeremy, can I just follow up on Homie's question, phrasing a little bit from the other side?
Yes.
So here's a worry that I had. I mean, your argument makes perfect sense to me. I, however, am very worried about something you only alluded to in passing, which is the dual systems that countries like the United States have frequently used on their side, as it were, of lawfare.
Yeah.
Namely saying that we were going to simultaneously subject people to an international law regime which they are definitionally violating, such that the moment they take up arms, they have violated international law and are guilty of war crimes, and simultaneously charge them with domestic law violations.
Sure.
Right? So the paradigm case of this is one of the Guantanamo detainees was somebody who was in his home. He was 14 years old at the time. He was with his father in Afghanistan. The United States military entered the home. He and his father fought back. His father was killed, and he managed to kill a U.S. soldier before he was captured. He was about to be charged with an international war crime in Guantanamo because he was not a legitimate combatant.
He was an unlawful combatant.
He was an unlawful combatant. When it came to the attention of the US government that they might find themselves in difficulties because people who operated drones in CIA headquarters were not wearing uniforms, so they'd better not charge them with the international war crime of fighting without a uniform, they instead charged him with a domestic US crime of killing, which has extraterritorial jurisdiction, of killing an American. So at which point he rather wisely pled guilty and accepted a somewhat reduced sentence and essentially repatriated to Canada. So the reason I bring this up is I'm concerned that by conceding that there's no problem with the insurgent pursuing simultaneous strategies of war and law, you may be opening the door for the other side to say, well, all's fair in lawfare.
Right.
And we can do this too. We can pursue simultaneous strategies as well, because why ought we not? No, I know you didn't make that argument.
I know, but
I'm worried that you may be blocking me from attacking the dualism.
Right. And I don't think I have an argument against that. I wanted to say that if part of the mixed strategy involves the government treating the person in accordance with the criminal law, then they have to accept the consequences of that strategy, which is making available criminal process, appellate process, habeas, and so on.
Only if they charge him, though.
Only if they charge him.
Because they can indefinitely detain him as a war criminal.
That's right, and if they choose that and that only, then maybe they can be consistent in opposing lawfare on his part. But I didn't want to take the converse position, which is that there would be something inconsistent for the government to try to work both sides of the street. Probably it might be impolitic for the government to do so.
Hasn't been.
Yeah, actually it hasn't been. So there's nothing in principle, I think, for the government facing some question of choice of forum, in effect, saying we could prosecute you militarily for a war crime, or send you to the ICC or whatever for a war crime, but in fact we're going to prosecute you for a federal criminal offense. It seems to me that that's a kind of choice that we face all the time, sometimes when we decide to charge people for civil rights violations rather than under the ordinary criminal law. So I'm not prepared to say that we have to block that move. We have to block that move.
Even if it means that we say we're going to give you a criminal trial, we give you the criminal trial, and if you're acquitted, we then detain you indefinitely as a prisoner of war.
Right.
Which we've also
well,
said
as you know, we do that with civil rights
Yes.
violations
That's true.
and ordinary criminal acquittals.
Agreed.
Yep.
Agreed. Yes, please.
Hi, thank you so much for taking time to speak to us today. I wanted to ask you about what I think I understand your thesis on the use of lawfare in cases where it would be it would effectively undermine the rule of law for both sides. So, for example, the case of insurgents hiding among the civilian population to incur civilian casualties. Would this kind of lawfare, which is meant to inflict harm on a stronger asymmetric foe, be substantially different from the very act of taking up arms against an asymmetric foe? In both cases, it seems that the jus ad bellum is arguably equally illegal for the insurgent movement. Why is lawfare different, or if it's not, what does that mean?
Right. I think the argument, and I conceded you're absolutely right, the point about deliberately hiding among the civilians so as to elicit killings of civilians by the other side, so as to embarrass the other side when those killings are brought to light, some sort of Goldstone phenomenon. I conceded that because there was a conscious attempt to instrumentalize the violations. I don't know whether there's anything equivalent in the simple act of beginning the insurrection at all. Insurrection is a well-known form of human political behavior. It's an extreme form and requires some sort of in extremis, if not last resort, idea to back it up. But at that stage, what one may be doing is simply taking up arms and hoping that this struggle will take place within recognizable norms of armed conflict, even if the other side is not directly recognizing those applicable. So I want to resist the suggestion that that even in cases where we disagreed with the ad bellum justification for the insurgency, that was in the same category as these provocations that I worry about. The case I wanted to condemn was a narrow case, because it really was supposed to be focused just on the business of trying to exploit and instrumentalize the fragility of the laws.
Time for I think perhaps a single last question. Here, please.
I wonder if I might ask a somewhat tangential question. Based on your remarks, do you have anything to say to us about what we should say about a movement that uses democratic means in an attempt to overthrow a democracy? And do you have anything to say to us about what the state's response to such a movement should be?
Yeah. I don't, and you catch me unawares of that. I mean, I'm perfectly aware of the problem. And some people believe that democracies have to be prepared to become militant democracies, to defend themselves strongly in various ways. And so in some countries, this has happened, and in some countries it's done well. My present colleague, Sam Zakharov, has written about this in a paper, and I think it's going to shortly become a book, called Fragile Democracies. He uses the example of Turkey, which 10, 15 years ago thought it saw a need to protect democracy against being undermined by Islamist parties working through democratic means. There have been similar concerns in India about the attempt of certain parties working through democratic means to nevertheless present themselves as sectarian Hindu parties, for example. And in both cases, what's been remarkable about the Turkish example and the Indian example is the variety of methods, as opposed to simple bans, a variety of methods that can be used, I think, to resist that sort of democratic Trojan horse. In India, certain electoral gains can be rescinded if it is proven that forbidden appeals to sectarian sentiment have been used to secure them. In Turkey, at least under what used to be the constitutional regime in Turkey, parties might be required to dismantle themselves and reconstitute themselves if they were guilty of using religious appeals in this way. So I think this issue of open democracy versus militant democracy is extremely, extremely interesting. But I'm afraid that that's about the extent of the knowledge that I can conjure up to answer your question.
Before I thank Jeremy for that dazzling presentation, let me remind you that we have one more component to our evening, our final panel, which will turn us even more expressly to the humanities and to the problem of asymmetry. That will begin at 6:30, if I'm not mistaken. Is that correct? Oh, 6:45. Okay. Well, we have a little bit more time than that. Good. So we'll now have just over a 15-minute break, during which you can stretch your legs. Let me thank now Professor Waldron for that very extraordinary presentation, and thanks all to you for being here. And once again, forgive me, this is very important. Once again, just down the hall, there will be refreshments and revival materials of the material sort. Thank you.
Thank you very much indeed.